Welcome back to Harvard Voices on Climate Change. It's great to be here for this semester. I'm Jim Stock, Vice Provost for Climate and Sustainability at Harvard. I'm an economist and director of the Salada Institute for Climate and Sustainability. Recently, there's been a lot of controversy around the construction of renewable energy projects in the United States. Some of this controversy has been on the front pages. For example, the Trump administration's withdrawal of permits combined with stop work orders for offshore wind projects on the East Coast that have largely been completed. Those permit withdrawals have been stayed by initial court orders, but the saga goes on. Other parts of the controversy have been lower profile and concern siting of onshore wind farms and solar farms. And regardless of the legal and political landscape, wind and solar projects in particular take a lot of land, and those land use impacts can be substantial at the local level. At the same time, solar and wind are low-cost, low-carbon sources of power that are especially desirable at a point of increasing demand when we need to decarbonize the grid simultaneously. So where does this leave the development of renewable energy projects today? We're fortunate to have two experts on land use and energy projects with us in this webinar who've been working on just these topics. We will first hear from Charles Taylor. Charles is an assistant professor at the Kennedy School at Harvard, who studies environment, agriculture, and climate change. He has been very prolific and has top publications in top economics and science journals. Prior to getting his PhD, he worked variously for Earth Partners LP and the Bill and Melinda Gates Foundation. Then we will turn to Andrew Mergen, who is the Emmett Assistant Clinical Professor of Environmental Law at Harvard Law School. Before coming to Harvard, Andy worked for years at the Department of Justice, where he argued numerous environmental cases, including before all 13 appellate courts and before the Supreme Court. After their opening remarks, we will turn to Q&A from the audience. I have some pre-submitted questions, but if something occurs to you, please put the question in Q&A. If we have any relevant links and updates, we'll put them into chat. So with that, let me turn this over to Charles.
Wonderful. Thank you, Jim. And it's great to have everyone here to tell you about some of my research and this kind of broader topic about how can we think about land use trade-offs in the clean energy transition. So as Jim said, I'm an environmental economist here at the Kennedy School, and we can jump into it. So today I'm going to try to highlight three things. So first, what is the current state of the renewable energy development pipeline? And in particular, as it relates to recent changes in demand growth, but also as we think about what kind of is going into the pipeline related to the interconnection, grid queues, and land availability. And then I'm going to talk about some empirical work that I've done that tries to understand a little bit more what can predict success or failure of renewable development projects. And here we're going to use evidence from actual land protections and land regulations and observe developer behavior in the past, as it relates to projects that they are developing. And then I'm going to kind of try to step back and frame this a little bit in terms of the overall policy landscape and potential reforms in this, as Jim mentioned, very dynamic and changing environment for renewable energy and energy more generally. I guess the takeaway punchline of what I'm interested in, what I'm finding is that there are ways to build fast and also protect the environment. Right? There is a tension that I'm going to talk about, but there are ways to kind of better target policy to kind of try to get more of a win-win here. So it does seem, you talk to developers, you talk to policymakers, it does seem like siting has gotten really hard. It's gotten increasingly hard to get projects done. And a lot of that is just because of the demand side for these projects and the demand side kind of in the backdrop for electricity. So, if we go back a couple of years ago, the story around this was largely this idea of net zero, right? How do we get to decarbonization by 2050 or kind of pick your date? And the general roadmap was we were going to electrify as much as we could, we're going to replace coal plants, we're going to get a lot of EVs on the road. And in order to do this, it required a large increase in renewable generation capacity, about a tripling under kind of most scenarios. And as We know renewables are really land intensive, right? While they're clean and affordable, compared to something like natural gas generation plants or nuclear, they just per megawatt, they're going to cover a lot bigger of a footprint. So this map here that you see is one of these net zero scenarios, which showcases what the kind of solar, wind, and associated transmission infrastructure footprint could look like under one of these. So there's this big space that needs to get filled. But then at the same time, right, what's happened since 2023, I would say, since the kind of advent of initial ChatGPT and the AI and kind of data center revolution, is we've just had to increase all of our forecasts for electricity demand. So there's been kind of an increase of about 166 gigawatts of peak electricity demand by 2030. The electricity use is also going to increase. I mean, data centers have a bit different of what their base load versus peak load requirements are compared to other users, but it's going to change an energy system, an electricity system that we were already trying to increase, but that was kind of in a status quo of being pretty flat and manageable pretty much since the post-war period, right? So this is this big step change on the demand side. And one way we can look at this is through interconnection queues, right? So this is what projects that are trying to get online, you need to be able to plug into the grid. And there's a process for doing that. And we can observe a lot about kind of what's going on in the market by observing what projects are going into the queue, i.e. requesting interconnection permission, and then what happens to them? How long do they stay there? So this chart shows kind of by solar, wind, battery, others, new projects each year entering. So kind of the story you see here is that most growth has come from renewables in terms of new projects entering by far. And there's a lot of capacity in the queue, right? About 2.3 terawatts, 10,000 projects. You know, this is much larger than the overall US grid currently has. But the problem is there's these long waits. 4 years is the average wait for projects, and as a result, a lot of these projects don't reach operation. And as a result, also a lot of developers are putting lots of different entries into the queue, kind of acknowledging that these kind of delays are going to happen, and a lot of the projects aren't going to go through. In 2024, we've also seen some changes under current regime. And we've seen a continued decrease in wind capacity, which has been kind of in the works for a couple of years now, but also an increase in gas entering the queue. So you can kind of think of this backlog as, anytime a wind or solar project is not built, that's kind of deferred emission reductions that are sitting on the shelf here. So kind of to all extents, we want to kind of get things in and get things through faster. This any change in policy or any change in regulation, a lot of which we've seen, is both going to kind of add a time dimension to this and a risk dimension that's going to change which projects get built and where they get built. And that's part of what I'm going to investigate. So there's a bunch of different ways one can look at what is the developer's incentive here, right? The kind of standard model has been these kind of market components, and this comes into a lot of the kind of capacity expansion modeling and kind of economic models you can have for a project, right? PPA prices, CapEx, OpEx, tax credits, etc. And then you have all the things about the where in terms of how you connect to the grid, what the costs are, how you upgrade in order to get that transmission to be accommodated. And then there's all these kind of legal things, which we're going to talk a bit about today, right? So NEPA, Clean Water Act, Endangered Species Act, easements, these are things that can affect the probability of your project succeeding as well as the cost. And then a kind of a related set of conditions related to the local community. So the kind of some of the research I'm going to briefly highlight here is that, where great wind and solar projects are, right? That kind of map I initially showed you of what the net zero project pathway looks like will not necessarily map to like where you can actually build. And we're increasingly seeing that both anecdotally and in the data, as I'm going to show you. So you add on to this other potential tension is that while we want to do this and massively increase the amount of land that we're putting into renewable energy generation and transmission, 1 terawatt of renewables, under some scenarios takes about 8 million acres of land, right? There's also these efforts to conserve biodiversity, right? With numbers like we need to protect 30% of land by 2030, right? So you and kind of think that kind of at its core, this is a competition over land to some extent, right? We both need to, if there's the goal of increasing biodiversity and conservation lands, concurrent with the goal of increasing the amount of renewable energy and overall electricity generation capacity. And there are a few of these tools that are used, which I'm going to talk about. So this I would say another thing that has changed over the last 5 to 10 years, that renewable energy is not constrained by its technical cost or the technology, right? It's this siting, it's this permission factor, right? And developers will say this in surveys, right? So this was a survey from 2024. 86% of developers say that permits and regulations delayed their projects significantly. And interesting, like 30% say that transactions fail due to some protected water feature, which is one of the things we're going to look into in the context of the Clean Water Act. And others have highlighted the role of the Endangered Species Act, Migratory Bird Treaty Act, and other regulations. So, this is reported. So, kind of one of the goals, of my research has been like, look, actually test this in the data. Can we quantify this? Can we see if this actually shows up? And so the first thing I want to do this with a colleague, Meredith Fowley at UC Berkeley, was to look at just at its base, is energy potential correlated with measures of conservation that we care about? Right. So what this chart does is shows what is the kind of engineering technical profitability of a given site in the US in terms, if you put a windmill there or a solar panel there, how much money you'd expect based on how windy and sunny it is and how close it is to the transmission, et cetera. How do those economics correlate with just different measures of what we consider important from a biodiversity or conservation standpoint? So you can pick prominent ones from TNC, wetland share, habitat acres, a bird habitat measure from the Audubon Society. And kind of what's interesting, at least at the national level, is there's almost zero correlation. So it's not that systematically good wind projects and good solar areas tend to be in disproportionately more fragile or more high value places for conservation. So what this means is that there's not an inherent, one-to-one trade-off here, but it does mean that, smart targeting is important to reduce the conflict. So, we can think of, as you increase the scale, you've kind of finished, you've found the low-hanging fruits of where you can put wind and solar and transmission projects. Kind of each marginal project is going to be more likely to kind of run into some of these local tensions, right? And so the policy goal should really focus on what this area in red is. Like where there's conflict is really just these sites that have both good renewable energy economics and also high conservation value. And we should kind of find policy and frameworks to manage that conflict, but kind of allow other projects outside of that to go forward where there's not this tension. To kind of visualize what this might look like to a developer in terms of a handful of the large federal regulations, here's a map of kind of what one is facing. These are three major ones. The red areas are areas regulated under the Endangered Species Act. So what this says, there's some associated, animal or something else that is protected under the ESA. And if you want to do something on those lands, there are certain requirements that you have to meet. It doesn't necessarily preclude you from doing it, but it might require mitigation, it might require higher costs, and it might result in delays. Blue is kind of the textbook Clean Water Act types of wetlands where there's high restrictions and permitting requirements if you want to do anything that affects a waterway. And I'll talk about that a little bit more later. But this, you can think of just like pretty much anything that's get built where you're moving dirt or using an excavator is going to have a water impact. and then orange is conservation easements. So in the interest of time, I will speed up here, but also, this is a local thing as well. When you zoom into any particular area, if you want to develop large-scale wind or solar, you're faced with a number of these land use constraints that are going to be very localized and specific, that are going to make it hard to get at a large land scale that doesn't encounter some of these. So we're going to put data to this. Projects can fall out during lots of different times of the project development pipeline. And what we're going to do is try to empirically test at each of these stages that we can measure. What do we see? And so here's kind of results from our empirical model on this that shows kind of what predicts where projects get proposed in the first place. So where you even kind of initially get site control to try to put forward a project. And kind of as you can see, the blue dots show that if it's on the right-hand side, it means it's kind of like good for a project. If it's on the left-hand side of the dot, it means it's less likely to help a project. And the economics kind of match what we think, where places with more output, we see more development. Further from the transmission lines, we see less. Land costs increase it, et cetera. But then we also kind of see this negative effect that land use restrictions have, particularly for wetland proximity, and also for easement proximity, conservation easements, which are these kind of legal restrictions that impede what you can do commercially on the land. And then secondly, conditional on you entering one of these interconnection queues, what determines whether you actually succeed in getting an interconnection agreement, which can take years to do and require additional costs. And here, largely the things that are reducing the probability that you'll succeed, i.e. what is kind of statistically significant on the left-hand side of this dotted line, are these land use protections. So again, wetlands, and the presence of easements in the overall area, which, where even if you avoid easements right where you're developing your project, if there are easements in the area where you have to go to interconnect to the grid, those can also be causes of that result in projects not succeeding. Yes, I am probably getting towards time. So, I mean, there's a lot more to talk about specifically in the context of the Clean Water Act, which I think is kind of one of the most important and interesting policies we've had here that we've had a lot of change on. There was a recent SCOTUS Supreme Court project, and it's just kind of important to note that this doesn't just affect renewable energy. These kind of land use regulations and water regulations affect housing development, commercial development, industrial development, infrastructure, road infrastructure development. And, to some extent, this has been called, here's a kind of a quote I like from Microsoft President Brad Smith, that it's the number one challenge in the US when it comes to permitting. It's not local, it's not state, it's the federal wetlands permit. So this is this kind of big thing that we have to deal with. It affects housing. I'll just zoom ahead to right here, is that we find that these policies like really do matter, and that they do have this real cost in terms of affecting where projects get developed and also the value of land. But that's all to say there's also a large benefit associated with these policies. That's also why we have them, right? Wetlands are associated with reduced flood damages. So I have some work here that actually tries to quantify that in the context of the Clean Water Act, of how much reduced flood insurance claims do we have from 1 acre of wetland, for example. They also have water quality benefits, habitat benefits, and these are all things when you're thinking about the cost of these regulations, both to housing and hedonic and property values, as well as potential reduced energy development. It needs to be considered the benefits of these regulations as well. Finally, we can move this to the Q&A, but this is just a really exciting, for better and for worse, time in terms of the regulatory landscape, in terms of FERC and transmission planning changes. There's a lot going on which could potentially streamline some of these processes. There's a lot of permitting and legal risk that has increased, changes to NEPA, the Department of Interior, executive orders, and then of course some regulation that I'd imagine Andy might get into some of these topics. So I will end there, and we'll look forward to the Q&A session. So Andy, or feel free to jump in.
Great. Really excited to be here and talk about some issues that are near and dear to my heart, which is related both to the permitting reform efforts and how permitting occurs and what the litigation landscape looks like. And I want to do three things in the limited time that we have today. And I think we can also get to some of this in the Q&A. I want to talk about what we know about permitting delay, the Trump administration's hostility to renewable energy projects, and how litigation has responded and what the future holds there, and what permitting reform and permitting certainty might look like. So the renewable energy permitting landscape is divided broadly into two sections: the federal landscape and the states. Now, the federal government owns and manages a third of the nation's land. And this is the part of the landscape that Congress obviously is most concerned about, right? It is in their remit, it is in their brief. And that's primarily what I'm going to talk about today. And as you heard from Charles, renewable power projects and transmission lines fall almost exclusively under several natural resource statutes, including NEPA, the Endangered Species Act, the Clean Water Act, the National Historic Preservation Act, and several bird conservation statutes like the Migratory Bird Treaty Act and the Bald and Golden Eagle Protection Act. I put this Clean Water Act here as a natural resource statute because it is not related to emissions from pipes here. It is related to the disturbance associated with wetlands conservation and fill and the like that is part of the construction of renewable energy projects. The state landscape is far more complicated because we have 50 states. So some states have attempted to streamline permitting through siting entities. That would include the snowy Commonwealth of Massachusetts, where I'm sitting right now. There are a variety of local land use and permitting laws, like conservation easements. There are state environmental impact laws in some states and some state species protection laws, but the landscape's very varied. I saw that one question in the Q&A relates to counties prohibiting solar energy development, and that is a function of particular state laws, and certainly it is a big issue when we talk about the permitting landscape. My remarks today are going to be primarily focused on the federal landscape. It's the landscape I know well from having defended countless permitting decisions in the federal courts for renewables and also for fossil and transmission. The federal permitting landscape has gotten a lot of attention lately, right? And part of that attention is a result of Ezra Klein, a very important public intellectual, writing with the New York Times. His podcast gets a lot of attention, and he's recently published this New York Times bestseller on abundance. And part of his thesis, right, is that we have too much process, and that is what is keeping us from having nice things. Likewise, in the legal academy, Nick Bagley, a professor at the University of Michigan, has written about, from a fairly progressive standpoint, that we just have too much process. Lawyers include too much process. And this is a real problem for the clean energy transition, for housing, for a whole host of things. And this is really the focus of a lot of conversation in the legal academy right now. One of the examples that everyone holds up is the battle over Cape Wind, right? This project here in Massachusetts, really the first of its kind project, large scale offshore wind in the United States, resulted in a 16-year legal battle that ultimately defeated the project. I was part of defending that project when I was in the government. And it was, I think it was frustrating for everybody that it was so hard to get this project off the ground, and it was ultimately defeated. I do think it's a hard project to hold up for lessons because it was really the first of its kind, and that made it sort of special. And it also that development occurred at a particular time and place. During my time at DOJ defending subsequent wind projects, we had more success Now, this case is one that was litigated, which adds to delay and uncertainty for project development. But it is a case that the same DC Circuit that had a lot of qualms about the process for Cape Wind was far less concerned with this case about offshore leasing in the Atlantic. And I think, Justice Breyer often says that they aren't influenced by the weather, but they are influenced by the climate. And I think again and again, you see, with some notable exceptions, the court sort of not being a huge impediment, federal courts being a huge impediment to renewable energy development. And this is an area of the law that is really not sufficiently studied. The NEPA process, the environmental impact process, the federal impact process, is in the remit of the Council on Environmental Quality, a very small office within the White House that has been chronically under-resourced. And so we don't have really a lot of data about what what the NEPA process means for permitting. We have a lot of thoughts from a large number of stakeholders, including some that Charles identified, that sort of say, hey, these statutes are really the biggest problem, whether it's the Clean Water Act, as the gentleman from Microsoft indicated, or the National Environmental Policy Act. I have been part of a group of folks working in this area, particularly David Edelman, who is an empirical legal scholar, who sort of questioned those assumptions that a lot of the opposition is focused on the National Environmental Policy Act, the EIS, EA statute that many people are familiar with, this look before you leap statute that requires some sort of hard look about the environmental impacts to make sure that the public and the decision maker are informed about those impacts. We think that there's a lot of myth making around the kind of impediments that NEPA imposes. And as Charles noted, the legal landscape is changing quite a bit. Now, David Edelman in Texas has done a fair amount of empirical research in this area. And what he has shown is that very few wind projects require environmental impact statements, which is the most robust of the look before you leap documents. It is the most time consuming to prepare. It has traditionally had multiple rounds of public comment. So it can be a time consuming process, but very few wind projects, this data, I should say, is up until from 2010 to 2021. Very few projects trigger the EIS requirement. Even fewer trigger the Clean Water Act requirements. That's the Section 404 column. HCP is an ESA requirement, a habitat conservation plan. So you have three federal statutes represented here, and you see that the numbers of projects that are heavily impacted by these statutes is actually quite low. That is also David Edelman has updated his data since that study, which was published in 2025 with data from 2022 through 2024. And again, we see that the percentages are relatively low. I'm not saying that if you're in that 9.3% that is litigated and you end up losing, that's not significant. It's really just that the numbers are more modest than we might assume right off the bat. And the acquisition of knowledge about the NEPA process and federal permitting continues, right? I think the latest numbers that David Edelman has looked at show that there are actually fewer EISs were done at the very end of the Biden administration, and that number continues to drop. So NEPA itself is not quite as high a hurdle as many people believe. What is a huge hurdle right now, especially to offshore wind development, is the administration. This memo that issued right at the beginning of the administration in 2025, freezing permitting, essentially an order from the president that said pens down in terms of moving forward on renewable solar and wind projects. And then more recently, the cancellation of 5 leases for projects that were pretty far along in their development. Now, the one thing about this is that the litigation trends here are not good for the administration. So, and this is all happening in real time. So, in the last, basically since January, well, actually, I guess since early December and continuing on through January, the administration has lost essentially six cases relating to its efforts to stifle offshore wind. Now, that's good news for offshore wind in the short term. In the long term, of course, as Jim alluded to, some of these decisions are at the very early stages of litigation. They will continue to grind on. And so long as they're in court, that uncertainty will persist, which is very unfortunate for these industries for sure, right? Um, so I want to talk a little bit about maybe what comes next, right? There has been considerable effort in the House Natural Resources and some in Senate EPW on Capitol Hill, so the House Natural Resources Committee, the Senate Environmental and Public Works Committee, a lot of thought given to permitting reform and what permitting reform should look like. Now, I think if you look at the studies that I showed early on the slides here, you'll see that there may be not a huge need for NEPA reforms. One, the administration has taken a large number of streamlining efforts already. The case law has changed from the Supreme Court recently, both in the Clean Water Act, as Charles alluded to, but also under the National Environmental Policy Act. So it's a very dynamic legal landscape, and the trend is not towards a more process. The trend is towards more streamlined, less process. But what really does call out for sure for reform is permitting certainty. That is to say that what are the limits on the administration's power to just cancel leases for these projects that are already pretty far along? Now, every court that's looked at it so far has said that the administration has proceeded unlawfully. But the uncertainty about the risks and lease cancellation clearly has a chilling effect on industry. So more recent efforts, and this headline is from earlier this month, right? More recent efforts have focused on permitting certainty legislation. That is some sort of insurance policy for developers who feel that they're at risk developing renewable energy resources where federal permitting is triggered given this administration's hostility to renewable energy. And so the consensus is also right that permitting certainty legislation must be tech neutral, right? That it must also provide certainty to fossil projects and not just to renewable projects. And that's the conversation that is occurring on Capitol Hill now. And I think if the administration were to support such legislation, it would find considerable support, bipartisan support across the board. The difficulty is that we don't know if the administration is willing to live with tech neutral certainty legislation. And this, I'll just say, and just in closing, that this legislation needs to do a little bit better, maybe, than the Freedom Act on the screen has done. This Freedom Act creates sort of an insurance policy, but it would quickly run out of money in terms of compensating folks for canceled leases. And of course, if you're concerned about climate and energy transition, you don't want to have to pay these people for canceled leases. You want the projects to go forward. So going forward, tech neutral permitting certainty is the key. And that is the issue that I'm most paying attention. And I'll stop there. Thank you.
Hey, thank you both. That's fabulous. Very interesting. We have a whole bunch of questions. So you should both feel free to jump in. I'm going to start with just some clarifying questions. Charles, do you know how onshore wind and solar compare in like a land, megawatts per acre, some land use measure? Like, how is there some way to think about the relative land intensity of these two different types of projects? Maybe you know some of these stats, Andy. I don't off the top of my head.
I have that that somewhere other than to say like compared to, I mean, right, nuclear is by far the most dense with like an order of magnitude more than natural gas, which is probably an order of magnitude more than solar. But like solar and wind are both kind of interesting because solar, wind has a more distributed footprint. Each windmill has, you have to have a certain distance of separation. So it looks like it's covering more land, but it will, each of the large turbines will be a large enough distance, which you can still have a number of land uses on it versus solar is more concentrated, but like almost all of the footprint that you have the solar panels on is no longer natural lands, right? I mean, has this land use cost. So it's hard to do it, hard to make those comparisons,
Yeah.
and there's like a lot of assumptions, but in general, I would say that's the kind of order in terms of land use intensity.
Yeah, that makes sense. Anyone who's driven through Iowa realizes that there's an awful lot of corn and beans that are being grown underneath those wind turbines. I think that makes an awful lot of sense. Um, Andy, can you provide, so you've spent a fair amount of time on the administration slowdown. You focused on especially the offshore wind permitting challenges or issues. Can you provide a little more detail on the onshore piece of this? Like I've read, and one of this came up in one of the questions that the Secretary of the Interior now needs to personally approve a whole bunch of categories of permits. So this raises the question of how is this how is the slowdown actually like being done? And is this then discretionary or through administrative procedures, or alternatively, have there been regulatory changes to make permitting more difficult
Yeah.
for solar for renewables?
Yeah, for renewables, the direction is primarily in the form of department internal operating procedures, right? Things that were previously relatively easily approved and could be approved from people lower down in the agency's hierarchy now have to go very high up, almost to, and in some cases to the secretary's desk. So that is has a profound effects in terms of slowing down the approvals of these projects. And what I want to say is that on the other hand, the administration has taken enormous efforts to streamline permitting for fossil fuel, for hard rock mining, and geothermal is also seems to be on the good side of where the administration wants to land. So that's the only renewable that seems to benefit from the streamlining. When I talk to people who are project proponents, who work even in extraction, they're often made a little bit nervous by both the sort of asymmetry that the administration has imposed, and also that some of these streamlining efforts may ultimately backfire in court, right? That courts are used to a certain level of process, and if they
Yeah.
don't see it, these projects may be slowed down, even as the administration is trying to speed up certain types of energy development.
So are those streamlining processes that the administration is speeding up, are these being done through new regulations on hard rock mining and new regulations for geothermal and so forth, or just being done through implementation? But then this gets back, I mean, look, they're not the first ones to use laws to slow walk something. I'll give you the example in the Biden administration of putting a moratorium on new LNG while we do a 2-year study of whether or not, whether or not that's a good idea for the country. And you get to you spent much of your talk talking about legislative permitting reform and the prospects of how that might be done. Uh, how sanguine are you about any legislative permitting reform when there's this enormous scope for administrative actions that can either supercharge or super slow whatever piece of energy infrastructure you're interested in?
Yeah. So at the moment, I'm not very sanguine at all for all of the reasons that you note, right? And that because I think there's this concern that you really couldn't trust the administration, right? You only want to take these steps in terms of permitting reform legislation if you feel certain that at the end of the day, the administration is going to honor that congressional effort. And the administration has a lot of levers to pull in terms of slowing things down. And I think it is important to note, as you did, Jim, that the Biden administration also pulled some levers to slow down fossil development, not just in the LNG context, but an early executive order on moratorium on oil and gas leasing onshore and offshore. Um, the when you go to the Hill and talk about these issues, the folks on the Republican side of the aisle complain that the Biden administration did the same things. And although I'm not sanguine, I think that observation just draws attention to the fact that we really do need Congress to do something that's tech neutral in the permitting reform space.
There was a question in the Q&A. Could you define tech neutral? Just clarify what you mean here.
Yeah, so what I mean is that uh, permitting reform that doesn't benefit one type of energy over another. So really, maybe I'm making it too complicated, but we can't have a system that benefits solely fossil and prejudices renewable, or a system, in my opinion, that promotes renewable at the expense of fossil, just because I think realistically the only way to get permitting reform is something that treats all sources of energy more or less alike, even though, you know, fossil has over 100 years of Congress promoting the development of that resource, and we do not have the same history for the renewables.
Yeah, and so I know this isn't this is a seminar, this is a webinar on land use, not on FERC. But a question that came up and sort of implicit in what you just said is living in the background of not just solar permitting and wind permitting and natural gas permitting but it's and pipelines, but it's also transmission, and that complicates the discussion quite a bit politically. So I wonder if you, and a question did come up about this. I wonder if you could say a little bit about permitting reform, transmission, and I don't know if you want to venture into it, but there is this question of whether permitting reform is actually the major impediment or not, even in transmission, and whether that actually has to do with FERC's limited ability under the Electric Power Act as opposed to its authorities for essentially eminent domain for gas pipelines. So maybe you could wade into this a little bit because it is a relevant question.
Yeah, no, I agree. I think that the author of that question is making a very astute observation. Like, the permitting reform issue is not the source of many of our problems. This transmission issue is really the source, and that is different. And we should encourage Congress to pay more attention to that issue, whether it's giving for different and more expansive authorities, which I do support. Um, Permitting reform tends to be, I think, sort of suck a lot of the oxygen out of the room, because it's easy for Congress to talk about. There's a broad coalition of folks who are anxious for permitting reform. It can bring the renewables and fossil together in some regards. But I agree with the questioner's premise that in some ways, or maybe it's your premise, Jim, but either way, I agree that these are different issues, and the transmission issue is by far the more important. And part of the reason it's more important is because so much of the gains of permitting reform that people have been looking for have already occurred, in part through the Supreme Court, right? The scope of the Clean Water Act, as Charles's talk noted, is greatly reduced. The court has issued a major decision about the National Environmental Policy Act within the last year. That will change how NEPA it works. Congress should focus on transmission for sure.
I don't know. Yeah, you should jump in, Charles, because
yeah, just to highlight, I mean, aside from the legal side, like why this, is so hard in transmission is you kind of saw that map that I had of all the patchwork of regulations. So when you have a linear infrastructure project, right, just something that just might not have that big of a footprint, but it's a big transmission line that just crosses a lot of places and features, right? You're gonna run into things, right? It's inevitable. And there are different kind of ways in which regulation is streamlined for pipeline development that I think are not applied to transmission lines, which makes it more difficult to kind of have a coordinated entity, facilitate these projects, which are so right. I mean, you think about where the wind and solar goes and how to kind of get the increase in capacity that you need, right? The whole kind of footprint and configuration and intensity and land use, if you're concerned about these conservation outcomes, will be a function of where you're where you're able to get those transmission lines is going to have a really big effect on what that looks like beyond just whether you can get a wind or solar projects permitted.
Let me jump to another. Sorry about this. Let me just jump to another set of questions. So okay, so here's a big question. One sentence. This is great. I love it. This is how can we decouple policy with renewable energy development such that it remains resilient across political agendas? Anyone have the answer to that question? Decouple land use policy and renewable energy deployment such that it remains resilient across political dimensions. I mean, agendas. I mean, this is sort of the big question of how can we find a durable centrist, a durable solution that actually spans our takes it out of the political debate. And there's a related question here, if no one wants to jump at that, which is hard. There's a related question, what can we learn from, we have years of experience about either engaging local communities or not engaging local communities. So not all of the issues are, you talked about federal issues, but a lot of these issues are local community issues. And so to what extent can local communities or local states be engaged in a way that's constructive so that they can see value out of these sorts of projects?
I mean, I'm sitting here, a lawyer with two economists, so I guess I have a question for you, which is, to what extent do you think that the conversation around affordability might lead to resilience in this space? I mean, this is cheap power at the end of the day.
I mean, let's see, I think one of the intrinsic challenges of the current administration's stance of slow walking things like solar, when the reason that there's all this solar in the queue is in part because of the IRA credits, but those things are going away. It's because solar is just so cheap. So that's cheap electricity. And so I think that, that's got to be a potent argument there. I don't know, Charles, what do you think?
It's really, I mean, I don't know, my read is there's been increasing kind of local skepticism around, big renewable infrastructure in one's backyard, right? I mean, that kind of, not wanting that nearby. I mean, you're seeing more and more of these county ordinances that folks, I think, there were mentioned in another comment, and that does get, it does make wind and solar difficult because these are land intensive projects, and like kind of acknowledging that like it has to go somewhere is a big, I mean, like the first order, condition that, but we do see these kind of some of these state level preemption programs. So that think of this as like, California and New York and these states that were having all these challenges where they wanted to meet their renewable energy goal, but local communities were stopping the projects, or county ordinances were getting passed, and it pretty much kind of like took some of the power away from local communities. So I don't know. I mean, like, I'm not an expert in that, but I see that as a very real tension where just as like renewable, affordable housing and building housing is kind of a similar type thing of like, how do you manage what the real interests of the community are and make sure they have a voice without, still allowing these things to get built is a tension that I don't think we've figured out, and is kind of core to that whole abundance, narrative that Klein talks about, and which I think I guess I'll to just frame this one more thing where I'm optimistic when I was kind of thinking about this presentation, where to go is that like if solving this problem of how to get things built in, faster and better, and just kind of acknowledging kind of a more, action oriented way of moving and thinking about permitting reform, we'll have a lot of externalities beyond just renewable energy, right? We'll just like get more built services done at lower costs, increase confidence in government to provide public services, better infrastructure. I mean, these are almost all things that I view as like important to get right. So the fact that there is some bipartisan agreement, or at least consensus, that like let's get the permitting right, let's kind of figure out what we can get through, like, is encouraging to me.
Yeah, I'll just say one very quick word about what makes me optimistic, because I think, in terms of community opposition, we have just scratched the surface in terms of what might be offered in terms of community benefit agreements, in terms of
Yeah,
obtaining social license. I feel like
yeah.
we are still at the beginning stages of understanding how to do that well. And I think when we get better at it, we're going to get more buy-in from communities. We just haven't done it very well.
That's great. I there is there are a number of questions on I know this is a little off topic, Andy, but you're going to be talking about this tomorrow night at Harvard. There are a number of questions on the endangerment finding, and I know this is off topic, but could you just start with just maybe a brief explainer? Does the endangerment finding have anything to do with what we're talking about just now? All of the land use and so forth. The withdrawal of the endangerment finding. Maybe you could just briefly explain what that is, and then just the quick explainer.
Yeah, so the endangerment finding, there was a long legal dispute about the ability of the federal government under the Clean Air Act, right? A statute that had its birth in the 70s, the ability of that statute to reach greenhouse gas emissions. That was resolved in part as a result of a Supreme Court case, Mass versus EPA. And it was determined that EPA did have the authority to regulate these pollutants and has done it in a number of sectors, including automobiles, oil and gas, land, and power plants, right? And that is really important in terms of combating climate change and just actually in protecting human health. I guess one nexus that I see, so in the administration is repealing the endangerment finding. It finds that it lacks the authority under the Clean Air Act for a number of reasons, to regulate in this space. That is going to be the subject of considerable litigation that is going to take some time to unfold. One nexus, right, is sort of how do we want to think about our public lands, which is just something that I think about a lot, right? In prior administrations, we have seen some effort to, as a result of the endangerment finding, as a result of a commitment to curtail methane emissions, to tighten up the regulatory regime on oil and gas operations on public lands, of which there are many, right? There are many oil and gas operations, both onshore and offshore. And if we move in a different direction, I feel it seems like that also makes it harder for us to think about these really excellent issues that Charles has highlighted, like just how should we think about using these lands and deploying them for green energy, right? Think about the relationship between high value conservation lands and lands where we can sustain, big solar, industrial solar operations and the like. This focus on oil and gas to the detriment of all other things takes us away from the serious conversations we should have about using lands for renewables. And that is clearly part of the goal of the administration, right? To accelerate and continue to accelerate fossil fuel development even in the face of like in the face of reality, certainly when it comes to things like coal. I don't know. How was that, Joe?
That was actually very helpful. That very helpful. So not unrelated, but certainly not on the same legal, not just sort of different legal families. Okay. let me turn this back to Charles. I wonder if you have any further thoughts on one how how can one prioritize? So you list a whole bunch of different possible impediments, and I know your research has looked at these different impediments to actually building. How can one sort of prioritize the ones that are the most important, where you're going to try to tackle what regulatory challenges you're going to try to tackle first off, in terms of in terms of addressing some of these problems in a way that still achieves the environmental goals. Like how do you that you had the slide with this long list of many different things. How do you sort of think about what are the highest priority ones from an economic perspective?
Our research, I mean, the results suggest that as we can measure it, two of the big ones are wetland and water protections under the Clean Water
Yeah.
Act, Section 404. And what we've looked at was kind of the pre SCOTUS Supreme Sackett ruling regulatory environment. Right. So if anything, I think now kind of going forward, wetland constraints are not going to be nearly as binding or as costly to developers, perhaps, going too far in terms of losing important wetlands that have big habitat and flood protection value. So we'll be able to kind of see how that plays out, and we are seeing more stuff is getting built in places that wouldn't get built before that's near these wetland areas. So that has kind of, that there's a natural experiment that we're seeing play out here, in terms of the one that's thought a little bit less about is these conservation easements, which
Yeah.
are these things that are the largest source of new conservation land in the U.S. It's some estimates 25 to 40 million acres, bigger than the Conservation Reserve Program. So really, when we think about what's the marginal increase in conservation land, it's a tax and an IRS type ruling of around tax deductions, and those get really tricky because those are encumbrances on the land that like legally prevent certain activities. And if that's there, it's a lot harder to kind of do a project if you're encountering some of those legal constraints. But at the same time, it's not a regulation, right? I mean, those like the conservation easement program could be amended through a number of channels, which I'll defer to the lawyers a little bit on that. But it's a really hard one, but there might be tweaks and fixes that could help get some of these trade-offs and get better win-wins where you could actually develop certain types of things on conservation easement lands while still maintaining your conservation easement status, for example.
Yeah. Andy, anything to jump in on that?
Nope.
Okay, so this is a little bit hard. There's a whole bunch of questions asking something that we all hate to do, which is to make forecasts. And there are all these different tensions and different forces going on. There's the regulatory, there's the changes in permitting tempo. There's Supreme Court decisions that are coming forth, and the disappearance of the IRA tax credits. Do you have any sense in terms of how much this is actually slowing down and will be slowing down wind and solar deployment over the coming, 4 or 5 year horizon?
Maybe I'll briefly, I mean, I've thought about this a lot. Wind has been slowing down prior to this, right? I mean, it's been the
Yes.
story of like wind peaked in 2011 and solar's been going up.
Yeah.
In the interconnection queue, in terms of like actual capital investment in 2024, 2025, we've seen kind of solar flat or slightly declining from its, previously very high levels. As you mentioned, a lot of people are just racing to get the the construction started by July of next year to get these tax credits. So far, the story doesn't look too bad, especially just given the inherent economics of solar, but it's going to be, I can't say that will extend for another year and a half or two. But I would say the upside of that is that, you look globally, right? Solar is continuing to get deployed. These supply chains are there. Like it's not, solar is not going away. And as battery technology continues to improve, the kind of ability for us to kind of plug into an actual baseload type solution will only increase. So I'm pretty optimistic about wind. But again, I would say like there are other wins that we can have right now in relation to geothermal and investments in nuclear that like could also, we could see a lot of progress. And that combined with permitting reform, I could see a world where it doesn't look too bad in a few years. I could also see a world that it looks pretty bad, but both could happen.
I think we like to end on the optimistic note. So I think that's a good place to go in a sense. I'm actually I've gone a minute over. So thanks everybody for joining us today. I'd like to thank both Charles and Andy for their great comments, and also the Harvard Alumni Association and our production staff here for all of their hard work. If you'd like to hear more from Harvard faculty on climate and research and solutions, we invite you to subscribe to the Harvard Climate blog. The link is going to be in the chat. And so thanks again for joining us today, and we look forward to seeing you next time.